Well, ladies and gentlemen, welcome to the third webinar of the year with Sprout Agribusiness. Today we have a pretty light topic. I'm just joking. It's going to be very insightful in this geopolitical world. Um, High diesel prices, urea is going through the roof. But let's step back and talk about asset protection and trading structures. My name is Glen Simmons. I'm a succession planner at Sprout Agribusiness, and I'm a facilitator that works with predominantly farming families to help with the transition of assets and business, as well as help grow the business as they move forward throughout the years, and making sure that there's correct viability financially and through governance as well as the family moves forward. And a part of that throughout my work is there's a major topic at the moment, for one reason or another, is around asset protection. And what ties in well with that is how the ownership strategy is selected moving forward through different trading structures and alike. Today, I'm joined here by Will Harris. He's a lawyer at Long Saad Woodbridge Lawyers. He specialises in wills and estates, succession and commercial law. He has a background in regional Australia, born and bred in Wagga, and he understands the challenges of family businesses and investment management. Will works with individuals and business owners to structure and protect their assets, taking a practical holistic approach. We don't want to get those two mixed up, Will. Across areas including companies, trusts, self-managed super funds to ensure long-term security for future generations. Will, welcome. How are you?
Thanks, Glenn, and thank you for having me on this evening to speak all things asset protection. Going very well, thank you.
No worries at all. Now, we'd just like to remind everyone that the topics covered today, you would appreciate, can be quite in-depth and quite specialised to each family. So we will allow some time for some questions at the end. By all means, you can ask a question throughout our presentation today. If you can just type in, and we'll be able to come to you at the end, hopefully. But if we just ask if you keep them general in nature, just so that we can hopefully answer them on the fly. So without further ado, I'll jump into this now. Just bear with me. I'll just share my screen and get the presentation underway. How's that look to you, Will?
Just a bit of black screen. There it is, Glenn, coming through now. Thank you.
Righto. So today's topic is asset protection and trading structures, and we'll jump into it. So asset protection number one, what is it? So it's structuring the ownership of assets to minimise risks, and we'll jump into a little bit later on as to what those risks may be. It's all about protecting the assets from creditors, legal claims and disputes. In succession, we see the major themes all the time. What happens to this asset in the case of a divorce? What happens to this asset if a legal claim comes through? So on and so forth. It's about separating the business and operating assets from valuable assets. So talking about the separation of entities moving forward, and using appropriate entities to limit exposure, and supporting long-term businesses for continuity and succession. And this is very, very important aspect that we look through when we do succession, as well as the governance piece when it comes down to choosing that trading structure, as well as the financial viability from once it is implemented for that owning generation and for the next generation moving forward. Will?
Certainly, Glenn. Nail on the head there. The main thing when you sit down and talk with some clients about asset protection, the thing you've got to just understand and dial it right back is we just want to separate that asset from the risk. So in doing that, we would just sit back and really make sure we identify what are the assets, and especially the capital appreciating assets, and how can we remove that from the risk. So putting forward to an example that I could explain what actually is asset protection. Say we have a husband and wife. Um, they own their home in their personal names. They own their farmland in their personal names. They also run their business as a partnership of humans in their personal names. And they have other assets, maybe, holiday home, cash, etc. So they come to us and say, we want to protect these assets. Well, as they hold them in their own name, it's actually one of the more riskier ways to hold your assets, because as you can see there on the right, a number of assets from number of risks from creditors. Just running your operating business. We find farms probably could be one of the most riskiest businesses to run, as well as you've got risks such as uninsured claims. Maybe they're going through litigation, and as Glen touched on earlier, family law. So in this circumstance here, those risks could certainly impact the assets that are held there by the husband and wife. So they're certainly in this circumstance exposed to, those risks. But when we sit down to do asset protection, you've really got to consider tax, the cost effectiveness to do it and implement it, because it's something that can't just happen, at a point in time. We always say when you're going to buy a new asset, or if you're going to go through the succession piece, or if you're looking at death, that is the best time to implement an asset protective structure, rather than just say, oh, I'm going to move my whole farmland now into a company. That's just going to cause you a lot of cost or tax issues. But I would like you to know that there are so many risks out there. And what we want to say, what I always mention to people is, you've really got to identify the risk and see if it actually impacts you. You don't want to go around boxing at every shadow, or you're never going to get forward with your business or your assets. So on that point, every family is different, but it's really about sitting down, identifying the risks and what are the assets, and seeing what we can do. So maybe a different type of structure that is often used in family businesses and family farms, would be separating the entities. So you can see on the screen here, on the left, we would have the land holding entity, whether it's a land holding trust that holds, say, the farmland. On the right, you have the equipment, plant and machinery over there. And then you would have the trading entity. Now, a husband and wife would control all these entities. And you would often have the land holding entity and the equipment entity leasing to the business entity. And by separating all of the depreciating assets with the land, the equipment, and the actual trading structure, which is probably going to hold the most risk, it is quite an effective asset protection tool. Now, you would see, I've just put it in the top, the husband and wife have joint ownership of, say, the family home, and maybe even their holiday home. You could look at that and say that is also in this structure, could be at risk. Say you're the directors of the trading entity, both of you, and you're providing director guarantees, or you might be aware that there's certain things like strict director liabilities that could impact you when acting as a director of the trading entity. So a suggestion we could always make to people when they're looking to put this in place is maybe we separate who controls these entities and who owns the other assets that you want to protect. So if you slide to the next slide, Glenn, I've tried to demonstrate that for the clients. So there it is there. You could see, the husband maybe controls all the entities and is the director, and the partner owns, the family home, the holiday home, etc. Now, obviously the downside with, that type of asset protective mechanism, because, each person's losing control of certain assets.
Thank you, Will. I'd like to just highlight too that anything said today is also general in nature. It isn't legal advice. Take it with a grain of salt, and obviously
Certainly.
each family needs to be assessed. But just want to highlight what Will is saying here, that apart from your business, of a lot of families we deal with, they've got the holiday home, say it's down at on the south coast. They might have one in Sydney, wherever else. But they've also got the farm assets, and they also might have a residential house in town. you really need to consider as we're moving forward within succession what is going to happen with the fate and also the risks involved with these off-farm assets, and what entities they are part of as well. So part of my job as a planner, I talk to professionals such as Will, who is a specialist in this. After we've been through the groundwork and the heavy rocks with the family, making sure that there's correct asset policy in place, correct roles and responsibilities, as well as governance within the entities that we'd like to create. And then we come to Will, and he can set up the separation of these entities. And I think he's done a very, very good job at visualising what it can look like, and how it can be set up moving forward. So that brings us into some common structures and entities that we see, and all have their pros and cons. And it can also it needs to suit the idiosyncrasies of the individuals within the family, especially those who are going to be within the business moving forward. And how does, especially if there's setups such as trusts and there are off-farm members in there as beneficiaries, well, how does that look like practically moving forward? So the major structures and entities that we deal with in this game is the sole ownership, being mum and dad, everything's in their name. And Will highlighted there what it can look like moving forward. Partnership can entail the trading entity and ownership. Biggest thing around this, you really need to nail down the exit strategy or entry strategies, and what does it look like if someone was to pull out of that partnership, particularly from a financial point of view. A company whereby members of the family, I've seen this in sort of much larger families as well, have shares within the trading entity, or the land can be held in as well. And of course, self-managed super funds. A hot topic at the moment. We've been presenting a lot of presentations like this with New South Wales farmers across New South Wales, and a hot topic is around, should I have land in self-managed super funds, regarding the way the government is looking at it at the moment. And neither Will or I will answer that today, but it's also a consideration moving forward. So the ownership strategies, when we're sitting down with the family and we're really taking a snapshot of where their business is at today, we'd like to try and identify what the business is and the land ownership is at the moment, and what it would look like moving forward. And you can really categorise a lot of these structures and entities into 4 common ownership types. And there's also a cross-section with the ownership types and decision-making control. So whatever structures that we set up, for whatever reason, it might be asset protection in this case, we need to make sure that it's going to work from a decision-making control, and how that works from a governance perspective moving forward. Whether you do have a concentrated, a concentrated strategy being, say, a trust, a distributed strategy, which is probably not as common with a company, a sole owner or partnership. And I'm sorry, I did miss out on before the trust, discretionary trust, which is your straightforward family trust where you have directors and beneficiaries, and you can move them around at B and easily ship in power where needed, and a unit arrangement as well, whereby people have shares or units in that. But more often than not, we'll deal with discretionary trust within family. This is also sometimes a CGT, capital gains tax effective way, but we can go into that at another time. But another thing we do look at when we are picking these structures and entities, especially with transfer of ownership of assets, more often than not, we're going to look at the capital gains tax and stamp duty as well. So just to explain the ownership strategies, sole owner works best where there's a decisive single leadership is needed, and either sufficient off-farm assets or business liquidity exists to support non-owners. So more often than not, this can work if there's not too many people in the transition or the business, and if there's, sometimes there's maybe just one likely successor or couple moving forward. A partnership is a very common one moving forward when you've got two generations moving forward within the business. As I says here, works best where one or more family members actively participate and is supported by sufficient liquidity or additional assets to benefit the wider family and sustain the business. So there could be some off-farm family members that we need to compensate. What is the timing around this? And how long does that partnership go for until maybe that next generation takes over? And we've got to look at that sort of the length of time and the viability around that. What happens from an asset protection point of view? What happens with the ownership of the assets and the business? Is there a separation? Is there only partnership with the business, or is the assets included as well? Concentrated works well when business requires decisive action, even when there are multiple owners. This could be for a very, very large business when family members may not be involved anymore or they're being phased out. Distributed fits when majority of the wealth is in a single asset and may not require family operational expertise when there is no family member interested in the family business. So that concentrated and distributed can cross over quite a lot. Concentrated, you're probably seeing a lot more of your trusts, and distributed, you're seeing a lot more of your companies moving forward in those transitions. So the sole, I forgot. Sorry, Will, do you want anything? Would you like to add anything there?
Thanks, Glenn. I'm really just around, in this succession model, this is something that you would sit down, especially as you're trying to bring that next generation in and working with as the team, with the advisors, we try and make you understand exactly, the ownership structures that could work, especially in terms of things like concentrated and distributed. They work well, especially in terms of passing that control of those assets without, too complex nature in a way, because you could try and pass who has the hat to make the decision as you want to, give that control to the next generation.
No, very good point. Thank you. I will remind everyone that we are live and we're doing our best. So bear with us, but hopefully you are picking up some great points here. So the main challenges that we see with the sole owner approach is that the sole owner must understand the obligations of the wider family. Siblings may receive less than the business owning successor, and that might be the case. That family has set up their priorities, their vision, and what's important to them, because those people who are taking on the business and are within that there are to take on, say, the family farm or the farming assets, might be working in that business long enough to create that sweat equity to qualify for that. But family tradition often influences who takes over. This is as sole owner is a very, very common thing, particularly in times gone by with succession. The expectation to continue and preserve the farming business that needs to ensure alignment with the successor's personal and family goals. To consider the spouse, partner's expectations and future roles, and what does that look like, and confirm the successor has a genuine passion for the business, and also assess whether sufficient off-farm assets exist to support fairness. Now that's only in some families, but more often than not, we're seeing that. Will?
Yeah, I just think coming back to that asset protection piece, Glenn, is that, if you're owning all the assets in your own name as a sole owner, you're not going to get as much of that protection there. But when sitting down and discussing that with clients, maybe it is that, the farming entity, they want to go and they don't want the fuss or the ability or they're happy for it just to be in that, sole ownership, because the risk may not be that high.
Exactly.
So, not necessarily saying don't own anything in your own name. When it's passing, let's consider what the risks actually could be.
Exactly. Yeah, that's right. Not one size fits all, that's for certain.
Yeah.
Partnership approach challenges need a clear, as I said before, clear entry and exit rules for ownership. If someone were to exit suddenly, would the whole thing fall apart? Active versus inactive family members, this needs to be defined. Are they working the business full time? Are they not? Are farm family members, are they totally out of the picture? What does that look like? The asset ownership approach, operating company versus a broader asset pool. market value buyouts can restrict takeover and reinvestment. So, if there is a buyout of someone, as I said before, financial viability. What is the risk for the long-term business continuity? And clear employment policies define participation, set standards, and time commitment. Again, every entity and structure that we set up, whether it be for the asset protection or the viability, we need to make sure that there is clear governance in place. Otherwise, it will fall over. However, to have that baseline expertise put in there by Will, to make sure that if there was something to pop out of the blue, your family can be protected as the best way possible. It can never be perfect, but we need to make sure. Will, anything
Certainly.
to add there?
Yes, certainly partnerships, we see them work really well, especially when there's, those the exit strategies put in place. But one thing I often mention to people dealing with partnerships that they don't maybe pick up is a general partnership normally dealing with joint and several liability. So do we need to consider if there's two humans, they're not mum and dad, maybe brother and sister, and then in partners in their personal names, what happens if one of them has a lot more assets than the other, and that one that doesn't have the assets, gets themselves into some risk or some trouble for the partnership? Even though it happens over here with this sibling, this sibling's assets held in their own name could be exposed. So it's just really identifying, the risks of what everyone's bringing to the partnership.
Exactly right. We'll move on to distributor, the challenges there. Obviously, the issues there. No major owner requires clear. No majority owner requires clear decision-making frameworks. Again, governance defines how decisions are made and delegated. Risks of disengaged owners leading to asset sales. I'm sick of it. I don't really have as much control as what I'd like when I was entering into this. It sounded very exciting, but there's 5 of us within this trust. What are we going to do? Misalignment between owners and operators. Incentives may be insufficient for active participants. So really need to narrow down what drawings will be, and the policies in place. Say if it is a profit sharing system, the milestones and what the business needs to hit for these things to happen. Incentives may be and we need to ensure the ongoing viability, alignment of interests.
Yeah, and who sits on that board? As even as the company, as directors, who's got the decision-making power, and what directors are usually a lender would make directors give, guarantees and those things. So, what's the impact that could have? Say, if one director wants to get out, or that risk that having the person that owns all the off-farm assets in their name as the director, could that cause an issue if there was a director guarantee that went wrong?
And I will elaborate, in a few plans now, we've particularly for larger families, and there's a few moving parts, assets held in different trusts and everything else. A board structure has been implemented, and sometimes it's appropriate to bring in a third party to sort of break up that decision-making process and to be a voting member as well. Particularly if things do turn a bit pear-shaped and there are assets on the line, when legalities need to be involved or alike. But hopefully it doesn't come to that. But sometimes a third party is worth implementing into your family business. Concentrated challenges. Distributed ownership can solve some of the issues, but it creates new complexities. All right. So control becomes much harder to define with each generation, sometimes in these sort of circumstances. It can be unclear who ultimately makes a decision to exercise control, much the same as before. Risks that non-controlling owners become disengaged. There could be questions how non-controlling owners benefit from ownership. So what's in it for us? Can add complexity across the operating and land-owning entities. And that's where, when we come into place, put into these different entities, we need to make sure that it's going to be all very smooth, from just a practical level more than anything. Lack of clarity may create too much grey for decision makers. Risk that the structure becomes too complex and implement to implement effectively, as I was saying before, and potential for family tension and misalignment, which is not what we want when we're doing transition,
No,
Will.
no, not at all, Glenn. So, often when we're doing the succession piece and working through it with the family, having everyone come to the table, and whether it's a, shareholders agreement or certain ways that resolutions are passed, say majority vote, is something that we put, to all families, that just so everyone feels like they may be able to have a voice at the table if need be, if that's the outcome. Otherwise, it's, putting together just that control into, say, whether it's the shareholders agreement and everyone signing up to what they know to be the rules.
Yep, spot on. So we'll move into a bit of a very high level scenario. I hope our participants don't poke too many holes in this, but look, you'd appreciate that you can all make up have a bit of imagination to fill in the gaps. But scenario separating business and assets. So the Harper family farm, multi-generational broadacre operation, the transitioning toward a distributed ownership structure. Parents, John and Lisa, planning succession. Lisa is receiving a substantial inheritance in the near future from her family. 2 children, Sarah, 29 years old, and she's active in the business. Tom, 25 years old, not active in the business, and he's a solicitor in Wynyard. The key objective is to share wealth across the family while maintaining the farming operation. So, moving forward, Harper Family Trust is a discretionary trust. This may have been set up a little bit rogue. It might have been without a facilitator. We've come in and we've had a look. So holds farming land, plant and equipment, also holds the trading entities and shares. Red flag might go up there, Will. John and Lisa control the trust. Excellent. They're directors. The beneficiaries include John and Lisa, Sarah and Tom. So they've included Tom in this family trust, who is an off-farm member. Off-farm assets also held in the trust, house and town. There's a commercial property on the Gold Coast, earning 6% net rental yield, and that is a strategy moving forward for John and Lisa for their retirement. Situation, so there's no single controlling owner. Wealth is distributed across family via trust distributions. There's flexibility to allocate annually via beneficiaries, and all major assets are held within one trust environment. So we're seeing a few pros and cons here. And I've just hit that again. Sorry, we'll go to the next slide. So the challenge is there's a significant asset concentration in one entity. Everything's thrown in. They've been to their accountant. The accountant may be very, very good at tax and everything else, but they haven't thought through the practicality of this and what might happen from an asset protection moving forward. Will, you can take it from here for their exposure.
Yeah, look, just as we touched on right at the start, we've got to identify the risk and remove that from the asset. And now here, when you've got some off-farm assets mixed in with the farming entity, certainly could be exposed if there was a risk that really arose, say, from a creditor or a few bad years in the farming business, had a lot of debts to pay. So it's really that this structure wouldn't be something you would suggest. But the hard thing here is trying to unpick it, especially with, having a daughter on farm and a son off farm. So I'd more think about this would be, how are we going to pass control to the child? And one thing that, I often comes up here is that, Lisa mentioned that she's getting an inheritance. So she comes along before we go through the succession piece, and she says, Glen and Will, what am I going to do with this money I get? Well, the first advice would be not to, dilute it into the trust. It would be to separate it from it. And maybe that's, buy a yoga studio in Dubbo, or, invest it into something. And if it's done correctly, not that, in succession, anything's ever equal, but that's an easy way to give some capital to your, off-farm son when you do look to, transfer, say, the farming entity to the daughter on farm. Yeah. And then obviously the main one is that with everything in one bundle, as Glen's got on the screen there, there's a lot of exposures to a lot of risks that, the more assets you put in the same bundle, the more that they could be exposed.
Exactly right. And we could easily refer to I think the first slide that you had up, Will, is that sort of clear separation of what we can look to do here.
Yep.
Um, if it was a case of pulling things out of a trust into people's names to change into a partnership, and things like this, again, one of the first things we'll have to look at is the capital gains tax implications of that. And obviously, there's a few moving parts as to what concessions that the Harper family might be, what might be available to them. But we work with an accountant as well, in transition, to make sure that that's going to be okay. But from a high level perspective, these are the sort of things that we would address moving forward. I'll just go to the next slide. So succession goal, example, transition ownership to Sarah. I've got a little caveat there. That doesn't have to happen, beg your pardon, everyone, straight away. It needs to play into the timing of John and Lisa's asset policy. Sarah's only in her 20s, so they may not want to transfer any sort of ownership of land yet into her name. They might want her to, you know, get a few more runs under her belt. And, you know, they might have an asset policy which you need to work with in the business for 10 years before you can qualify for this land. Or, you know, you might need further education. We value our college. It might be like something like this. However, that is something we work within the family, to help the family step up and challenge and go, well, why is this being implemented? There could be um, you know, the side note of Tom might be working in Sydney for now. He might have a degree in ag economics, but he might also want to be integrated within the business, and the farm later on. So work really needs to be done from my point of view, from a facilitator, to work with the next generation to understand their business goals. And if there is a pathway moving forward, so that we can really set up the right trading entities as well as the asset ownership entities to help foster that pathway forward to allow for that to happen if the owning generation wants it. And I say it in nearly all of my webinars that when it comes down to succession and transition, it is really up to the owning generation, in this case, mum and dad, as to what they want. There's this sort of notion within succession that, oh, the kids want this, the kids want this, we've got to hurry up because the kids want this. I want everyone here that hasn't started any succession planning yet to just take a step back and go, hey, listen, we've built up this business to where it is. Even if we did inherit it 20 years ago, it is now worth probably however X amount more than what we had it for, but we had to work hard in those hard years. What are our policies? What do we want for the family? And are we allowing these things to happen? But it's all about working with all the generations to make sure that timing is going to be spot on, to maintain the integrity of the farming business. So if that were to happen, again, we don't want it all to fall to bits because of lack of governance, or it's not financially viable, or they're going to be hit up with a massive CGT bill which could have been avoided before, and ensure the equitable, not equal, treatment of Tom. So in this case, if he doesn't want to come back, what is the compensation going to be for him? He wants to buy a house in Double Bay. Good luck to him. Mum and dad are going to try and fund that as well. So overall, we want to protect the core farming assets. Okay. And this could be, you know, if there is different relationships coming into the business, if Sarah does marry, or if Tom marries, or if there is a relationship breakdown, or if there's something coming in from the side, from a legality point of view. This would be your field of expertise here, Will.
Yeah. Thanks, Glenn. And just touching on what you mentioned in that, slide before, it's in that process when, the facilitator and the accountant and the lawyers come together, we would just lay out the scope of different ways that you could try to achieve what you want. But the biggest reminder is always, tax. It's got to be the biggest consideration to how you're going to make it happen. But, we've talked about entities, Glenn and I, but there are always other approaches that we suggest to, parents when doing the succession piece around how we can, further protect, that asset that you're passing to your children. And a couple that often come up, one is, binding financial agreements. And for those that maybe not know what a binding financial agreement, you may have heard of, a prenup. And it's a set of, it's a document that a couple would enter into that would lay out what their assets are. And if they were to go through a breakdown of that relationship, it would provide how those assets are split up between the two. Great, because, in this circumstance, they can provide certainty, especially for the parents that are passing, the assets to the children, and really that protection. So an example maybe when dealing with, say, farmers is you want to pass, say, your land down to your children and they're already in a relationship, or they might be in what we call de facto relationship, not married yet. We could look at doing a BFA that, only quarantines that farmland asset. And we would say, this is what happens with the farmland asset. But, your other assets would just be left up to them to decide, or the court. So necessarily not doing a BFA that covers all the assets that they have. It's more just what they're inheriting. But obviously binding financial agreements and prenups, so there's always a few cons to them. And, a couple we always say is that, both the husband and wife that are, signing up must get that advice. They must get independent legal advice, which can often lead to issues. But the one we see is, what happens if your son's partner doesn't want to sign up to the BFA? Could cause because maybe there's some angst there, or confusion, or feel like she's getting cut out of the piece. And that's obviously just coming down to people like Glen and everyone who's facilitating and helping, making sure that everyone's on the same page. And the hard one can be, what happens if that partner doesn't sign up? We sometimes say, does your son have to walk away from that relationship, or can we, try and build something else in to the piece? But we often find, when people are receiving asset, that they work well, binding financial agreements. Another one that we often deal with and touch on is, second mortgages. So your kids have got the land. There's a first bank lender that's paying for most of it, but maybe not the whole market value that the parents are getting back. So we would often suggest to the parents, whether they should put in place, say, a second registered mortgage, just to give them some security, give you some security in your retirement. And even if, something goes wrong, such as breakdown of that relationship, could we, look at clawing back some of that capital. But it's really about securing the shortfall between, what the bank's lending and what the actual value of the land is. But we often see with some of the lenders, and we can work through it, but one of the cons can be, getting the bank, who's the first mortgagee on title, to kind of agree to the arrangement. And lastly, it's something that we always discuss when we're doing the succession piece is, yes, we're passing these assets maybe pre-death, but what about post-death assets? And often that will capture, your off-farm assets. And, one way we can deal with this to provide against the risks is, say, testamentary trusts in the parents' wills. And we often refer to them as, bloodline trusts, where the wealth is passed down for future generations. The only thing is with, what happens under the will and what can go into a testamentary trust is it's got to be an asset held in your personal name. So say if you own other assets into Vivos Trust or a company like we discussed today, it's very difficult sometimes to get those into the testamentary trust. So it's sitting down at the time and working out what can actually, maybe find its way into a testamentary trust. And from there, whether it's one trust for all your children, or we like to give more options. So maybe it's a single trust that's not forced, it's optional on that beneficiary, and they could set it up after your death and get the advice to, get a bit further protection on those, maybe off-farm assets. Thanks, Glenn.
Yeah, no, thanks, Will. It's add to that second mortgage piece is also a very, as it does say there, it can be an excellent funding tool for transition, particularly if the next generation is unable to qualify for a commercial loan, or can only qualify for up to a certain point. Mum and dad can then register that second mortgage over a certain, can be multiple titles, but whatever it is, but they can make up the shortfall and help that fund in and transition over. So that's a very good funding tool as well. Binding financial agreements, I mean, yeah, fantastic. But yeah, it can be a lot of difficulty around that. I'll also say that another asset protection tool is, and this might sound crazy, is that and if it's a case of it really matters that there's a bit of a can be tension or a bit of a breakdown between, say, two generations. You don't have to transfer that asset. You don't have to transfer that ownership. Okay, so succession is often viewed about the handing down of mainly just assets in one sort of hit. But if there's that gradual handover, that can happen as well, provided tax works as well. But we can also look at the handover of just the business. And if it's a case of there might be a loss of trust in that next generation, or they might not just be ready yet, or you figure they might not ever be, it doesn't matter. It's your asset. You don't have to transfer it. All right. So that's a good way of protection as well. But more often than not, that is the wishes of the family. So we need to work that into our plans. So in the essence, and in we're just mindful of time, 38 minutes that we've been going through. This is the conclusion, but the key takeaways are we can separate the asset from the risk. Okay, it is often possible, but from family to family, this needs to be assessed. We need to have the consideration into preferred ownership type that suits your family. Okay. Um, we kick off a succession. I meet with the family. I meet with the owning generation. I meet with the next generation. I've done surveys and meetings. Okay, what does your business look like at the moment? What is the personalities and the roles and responsibilities of each member moving in? And what is the preferred ownership type, which would work well from a financial point of view, a protection point of view, and a tax point of view moving forward, as well as an overall governance perspective. And sure, whichever part is taking as financial viability, so I'm already ahead of myself here. Tax consideration needs to be assessed at every stage. As we've said before, nearly the first one that we always assess is CGT, stamp duty, and land tax. It's something you're seeing quite a bit, Will.
Yeah, certainly, especially in maybe owning other assets within a trust that aren't, say your farming assets, maybe you'd offset commercial property, whether that's in a trust, and the land tax implications are often something that's not considered until it's actually forced in there.
Mm, absolutely. And as we've said, there's no one size fits all. So it doesn't matter if your neighbours
Yeah.
are doing it, doesn't mean you've got to do it. It may work for them, but it may be the absolute wrong direction for you. So it's important that you seek advice. The beauty of what we do as a facilitator, I work alongside Will for his expertise. We do the facilitation of all the conversation and sort of the high level structure of the strategic plan moving forward. And we've got very, very smart people like Will on our side to read through and make sure that it's going to work. Before we jump into any questions, Will, would you like to finish off and add anything there?
Yeah, no, thanks, Glenn. I just to recap, would just say, every time you're looking at purchasing an asset or, passing control, it's at that point, one of the first things you should consider is, asset protection and, how you should, how that asset should pass or be bought because it's at that time when it can be most effectively done. Because if you're trying to do it post that, as I mentioned earlier, tax and those things could certainly be a detriment that would stop you from being able to maybe, quarantine that asset from the risk. So yeah, but at that time of, purchasing or moving that asset down to the next generation, asset protection is something that would be considered and needs to be considered in that piece.
Exactly right. And as I say, in a lot of the presentations that we do here at Sprout, a lot of you might be sitting there thinking, where do we even start? Where do we start with transition? Where do we start with succession? Or you might be just stuck. So if I'm speaking to a mum and dad generation, please sit down tonight, crack a bottle of Penfolds, write down where is everyone in the business at the moment, and where do you want the business to be and the farming assets to be, and that can get you a high level start. And then you can call either myself or Will, and we can help to move forward. So no worries there. Thank you for listening. I'll just stop sharing my screen now, Will, and I'll just check the Q&A box. And we don't have any questions, which is totally fine because if you would like to ask anything a little bit more in depth with your own family, oh no, we've got someone here. Um, Older generation doesn't need to hand over assets if they don't want to. Advice on how to approach it to the next generation is expected to do all day-to-day running of the business, but gets blocked from older generation. Very, very good question. Um, that can come down to the expectations of when that asset might be handed down. That's when you start to have conversations about a clear policy and timeline moving forward. So even if they are expected to do all the day-to-day running of the business, hopefully out of a few conversations, maybe with a facilitator, that block might only maybe just be perceived, or we can work through it as to why that block is there. So that next generation can continue working and understand what incentive might be there at the end, or what's going to happen for their future, or that generation who is expected to work every sort of day in, day out, can just go, no, I've got some clarity. I'm going to move forward with something else. But that's a very good one. I'd probably like to go into that a little bit further because that can be for different from family to family. But look, we'll pull it up there. If you'd like to go back and watch this through, it will be on YouTube. Everyone that has participated today or has registered will get a link to that YouTube recording, and we'll send out contact details and everything else, so that if anything would like to be followed up, we can go from there. But again, I'd like to thank Will Harris for joining us here today. A professional on all levels. So and I appreciate his insight, most definitely. Thank you very much, mate.
Thank you, Glenn. Thank you very much.
All right. Thank you, everyone. Have a wonderful evening.